The statute says, these are for cause strikes, that no person who has formed or expressed an opinion concerning the matter that may influence the judgment of such person shall be sworn as a juror. That's pretty low standard. So what I have on the back of my voir dire, not to tip off any lawyers I'm about to try a case against over here in 3 weeks again, is that I have when I get someone who's proclaiming something that may exclude them, I have a little sheet where it's my how to close the door on a juror, and it's my go-to questions, and I say things like, and you heard me the last time, Rufus, you know what it is they say, well, I'm a little reluctant to award pain and suffering damages. How do I quantify it? You know what? I think I'd need more than 51% to award these kind of damages. You know what? I've been a defendant in a case, or a plaintiff in a case, so I may have some views about that. And then you say, well, how long are those views important to you? Do you hold them tightly? Have you held them for a long time? I take it that in 3 days, those aren't going to go away from you. You're going to have those views. That's part of who you are. It's important to keep your integrity in this process, right? You're not going to give away those views just because some judge tells you to, that you don't like pain and suffering damages. No, you're right. I'm not going to. And you wouldn't want to have to. In this case, would you? So you have your rules, and you get them really saying, you know what, I believe this stuff. It is what it is. Thank you for your candor. And you explain to jurors at the beginning. You say, listen, you guys are all qualified jurors, but you may be a better juror for a different kind of case. If I was a victim of a crime, I may not be in a good person in a criminal case. And so you're qualified as a juror, but you may be better qualified in other cases. So my questions are to find out whether you're best qualified in this case. And then I do all this work, and I get them to say all this stuff, and then the defense lawyer gets up and says, can you be fair and impartial? Yes. Boom, they're on the jury.
Or the defense lawyer says, but if the judge, I understand you said all those personal feelings, but if the judge gives you the law, you'd follow the law, wouldn't you?
Absolutely.
Oh, yes, I would follow.
Because who's going to raise their hand and say they're not fair? Who's going to say they won't follow the law? Exactly. No one, never. But there's a lot of cases that say that you can't use leading questions to a juror to rehabilitate them. Now, I'm not saying it works, but there's those cases there. If you ever need that brief on jury voir dire, you're welcome to it. I'll give it to you. You can file it. I've rewritten it a couple times. Having that statute, though, it's directed to the point. That's a good little trick.
I've never seen this statute before today.
She's never seen it. No one uses it because no one reads it.
But it doesn't say anything different than the case law, really. But actually, it's surprisingly weak. It's a weak statute because judges aren't going to strike very many people.
Judges are trained. If you can say you'll follow the law, you'll be fair and impartial, you're on the jury. When you should not be, according to all of the law and the statute. But
that's correct. Judges will probably
not all the time.
strike. It has to be pretty egregious for a judge to strike a person for cause. Because you can say, I would tell the lawyer, I'm taking everything into consideration, all of his answers, Gary. I just don't take into consideration his answers to your questions. I looked at it all, and I looked at his demeanor, and I think and I deny your motion to strike. Period. That's what we do. And of course, we're right.
It's a discretionary act that's not going to be reversed on appeal.
No, nothing. That's why don't object during voir dire. Try to pay attention to the jurors, okay? Don't bore the jury. And you notice a lot of my points are about this jury. They are the ones that are going to be deciding your case. Everyone says, oh, what judge are you in front of? Oh, what, the judge in a jury trial doesn't really matter. Maybe on some pretrial motions, or if someone gets, if a judge grants a summary judgment, that matters. But for the most part, in state court, summary judgments aren't granted, and for the most part, it's the jury that decides your case. They have the verdict. I loved when I was in a jury trial versus a bench trial. The pressure was on me in a bench trial. The jury does all the work. And then I do the sentencing. Okay.
To echo something she said, so the more I try cases, the less I do it like I was trained. So just a couple, you mind if I make just
No,
a point on
no.
objections?
No.
So, I object less than I ever did. I just don't object. Jury knows, every time the jury sees me object, they think I'm hiding something from them. And they think that my client's about to kill the whole deal with some terrible answer, right? Because the code word, when jurors think of lawyers, they think liars. And as a plaintiff's lawyer, I have no credibility because of the marketing efforts of the insurance industry over the last 15 years. So I have no credibility. So it used to be when I was trained, you win your case in voir dire. If you don't win in voir dire, you win an opening statement. And if you don't win an opening statement, you win it there, right? I do the exact opposite. I under-promise and I over-perform. So I try not to win it in voir dire. I try not to win it in my opening, and I let the blooming flower of the evidence throughout the trial persuade them over time, and then they're like, "Wow, this is the real deal." He wasn't full of it when he stood up and said a lot of stuff. This is the real deal, and you let that persuade them. So by the time you're closing the deal, that you have that credibility, and you have it. Then that's it. You know, just like a sports team, the Cardinals have to peak at the right time in the playoffs. You know, you can't win 20, 25 games in August. What's the point? And that's the point in the trials. You want to peak on your credibility and your evidence at closing when they're ready to go make that decision.